A lot of noise. Hi, my name's. Oh my God. Hi, it's Ahaji from Ahaji Amos PLLC, and today we're going to talk about whether you can trademark your clothing line. Let's start off with a little bit about me. I am a small business attorney. I represent startups, solopreneurs, small businesses, and pretty much business of any size. My background is in big law. I've spent most of my career working at really big law firms, representing Fortune 500 companies and multinational companies. So I sort of know both sides of the pond, and I've chosen to represent the little guy now, and I enjoy that much better. So hopefully this video will be helpful to you. I do get a lot of calls about whether you can or whether one can trademark their clothing line, and so I do want to go over that a little bit. So a trademark distinguishes the products of one company from the products of another company. So a trademark is an indicia of source. Now, anything can be trademarked as long as it's used as an indicia of source and it's not functional, right? It needs to actually just function to tell the public, hey, this is where this product or service comes from. So the short answer is yes, you can trademark your clothing brand, but there needs to be a little bit more discussion in order for you to really understand. So when you say trademark a clothing brand, I'm not saying you can actually trademark the individual pieces of clothing in that line. I'm saying that if you use a certain word or phrase or logo or symbol or whatever to distinguish your clothing line from that of another, that's protectable under trademark law, not the clothes themselves. So I'm not saying that the shape of the clothing, the design of the clothing, that's all functional and it's not going to be eligible for trademark registration. What is eligible is the actual mark itself, as it is an identifier of the source. So how do we know if it's a trademark? If it meets the basic definition of a trademark, you should be using it as a source indicator, which means it should not be, generally speaking, it should not be prominently displayed on the outside. So I get lots of people who come in with t-shirts and the logo is on the front of the t-shirt and they want me to file a trademark on that. Well, that's not gonna be accepted by the trademark office. The trademark office wants to see your trademark used where trademarks are traditionally used, which is an indication of source. So when people are looking at clothing and trying to decide where does this piece of clothing come from, they're going to look at the tag. So your trademark should be on the tag that is attached to the clothing. So the sales tag with the price, there's usually a logo tag attached to it. That is the proper way to show a trademark use, not on the front of the shirt and not a pattern that's on the shirt or whatever the garment is. Another place you can look for a trademark is going to be on the inside. And I say inside generally, I mean inside the shirt. So like inside my shirt, there's a tag in here and it's going to say where the source of the shirt. Again, not on the front. You're going to have to look on the tag. It could also be in the inside of the pants. The inside of the pants is generally where you're going to find the logo or the trademark that represents where you can get that item. In terms of shoes, it may be on the outside in terms of a shoes. If you have a sneaker and you have that Nike Swoop is definitely a trademark that's functioning. Shoes are a little bit different in that there are trademarks that cover shoes and footwear where that trademark is going to be on the outside, and that's because the public tend to look at the outside of the shoe to figure out where that shoe came from. So if it has a red bottom, for example, or if it has a certain symbol on it like Nike or Converse or Reebok, they may have their symbols on the outside. They're also going to have them on the inside, but they're going to have them on the outside as well. So you want to make sure that you're going to use that trademark in a way that's consistent with how the public usually searches for that source. And so you want to put it where the tag is, or you want to put it inside and not outside. I get a lot of people who get hung up and lose their trademarks because they're sending in specimens of clothing with that pattern on the outside. And so you really want to not make that mistake. Now, there are a couple ways to actually protect the clothing itself. So you could file a design patent, and the design patent would actually protect the appearance of the clothing, but not the function of the clothing, right? But that's what you want as a designer. You want the appearance of the clothing to be protected. So a design patent is really the way. The thing with the design patent, as we know, is that the design patents are limited in time. Trademarks are not. You can have a trademark forever. As long as you're willing to pay that trademark fee, you can keep your trademark and you can enforce it against other people. Design patents are not the same. A design patent is going to be limited in time. So after the specified time, you will have to give up that patent to the public. Now, some people are saying online that you can actually copyright designs for clothing. That's both true and untrue. So you cannot get a copyright on clothing because it's useful. Copyrights are for fanciful works of art, generally speaking, unique works of art. They don't really cover clothing per se. So you can't design a new pair of cargo pants and then get a copyright on there. You can design a new pair of cargo pants and get a design patent and then trademark the logo that you put on the tag, but you can't use copyright for that reason. There are elements that you can copyright, however. So the fabric itself, if the fabric has a unique pattern, which is fanciful and artsy, and beauty is in the eyes of the beholder, but if it actually has a pattern on it that is unique, you can copyright the design on the fabric, right? So the design on the fabric, but not the shape or configuration of the clothes itself. That's protectable. If you have sketches of your drawings or sketches of your patterns, those are also protected under copyright law. So that's what we would do. So when the clients are coming to me and they're saying, hey, I have this new clothing line and I want to protect it, I'm going to use copyrights, trademarks, and patents to give that full body of protection around that line. So if you're working with somebody, make sure that they're using trademarks, copyrights, and design patents to protect your clothing design. And I have gotten a question about, which one would I choose? And for me, the strongest level of protection is going to be with the trademark because patents require a direct infringement. It's harder to infringe a design patent, but it's much easier to prove trademark infringement because there is no evidence of copying required like it is with a copyright, and because you can actually have a confusingly similar use and that will be infringing. So the standard there is confusingly similar based on consumer perception. So the protection is much more broad. And I hope this helps. Good luck on your clothing line if that's what you're doing. Good luck. Make sure if you have a new clothing line and you're planning to advertise that you look at a few of my other videos that talk about sponsorship and influencer marketing, because those are really going to be important to you as a person who's hiring social media marketers. All my contact information is below and on the slides that are about to come. If you have any questions, please feel free to reach out.